All right, representing sellers like a pro. Who here does more listings than buyers? If that's you, just say I'm a listing agent, right? Put it in the chat. If you deal with more buyers than sellers, I want you to tell me I want to work with more sellers, just so I could see who's here in the chat and who's here in the group, so I know what kind of experience levels you guys are at. Although this is a good class for any type of agent. So a little bit of myself: I'm a real estate and title attorney. I have a law firm. I have a title company. I've been at this for about 13-14 years now. So I've been around, and I love helping agents. I love teaching agents. It's kind of my thing. So but a little bit about how we work with agents and how we close deals. We order all our transactions and our orders up front. We're a multilingual team, speaking Spanish, French, Italian, Portuguese, and English. Super proactive to communication. So we have weekly updates, manual file audits, high-tech systems and workflows, free in-house transaction coordination on every single deal, and client satisfaction guarantee. We don't charge a settlement fee if your client's not happy. So I'm told that this is a really awesome class by a lot of people who watch it. So I want you to tell me what you think about it at the end. And if you like the way I teach this class, I want you to think about how well and how awesome we could do to support you in your deals as well. So let's just get straight into it. And some of these, so we're going to be jumping around with the contract. We're going to be jumping about in some practical scenarios. But you know, one thing that we need to think about is, who are we meeting? Who is the seller, right? And who is listed on the title on the property appraiser. We're going to talk about the property appraiser some more in a little bit, and the deed information. But I want you guys to think about, who are you sitting down with at your listing appointments? Are they the property owners? Do they have authority? And does their name match? Like, so when you schedule your meeting, you should already know with the folio who you're supposed to be, having that meeting with, right? Who is the appropriate person? If not, you need to ask. And then also, if their name, maybe their first name matches, but their second name doesn't match. Why I tell you this, to think about this, is what happened to require a name change? Usually when there's a name change, divorce, death, marriage might trigger one of the other things you need to think about. So as part of you're going to hear this a lot, as part of your onboarding process, as part of your intake process, you want to make sure that you're at some point, once you know you are sitting down with the right person and they're going to sign that listing agreement, make sure you're meeting and you're signing with the right person. Make sure you have a copy of their ID on your file. Make sure you ask if you have a name, if you have a name issue that doesn't match exactly, ask what the name change is about. So that might trigger other things that we're going to have other slides about. Okay. All right. So who is the seller anyways? This is Broward County Property Appraiser screen clip. And so we did a closing on this property. It's changed hands now already, maybe more than once. But this is a screen clip. And the reason why I have it here is because there was so many mistakes that were done because of the way this property appraiser looked like. So you'll see here, it says McDaniel Augustine, McDonnell Fred, and then Carl ETAL et al. So does anyone know in the chat? Does anyone in the chat know what ETAL stands for? I'll give you a hint. It's not Carl's last name. And others. Yes, exactly. It basically means there's not enough room on the line in this part of the property appraiser site. It's used on legal documents as well. There's not enough room here for the person, for the names. So on the contract, on a listing agreement, there should not be ETAL anywhere there, right? You should have all the names listed out. Even if there's not enough room, find a way to make room, because ETAL will not be an enforceable contract and it's not part of anyone's name, okay? And I say this because I've had contracts where someone gave ETAL as part of the name. So if one person did it, the other people might do it too. And then also you'll see here, Fred's last name has a typo. It was McDaniel, but for some reason there was a typo. So it's really important we look at previous deed to know exactly, make sure there's no typo, because what happens here, this is filled in by a human. And what do humans do sometimes? Make mistakes, right? So we want to make sure that we have that verification process. And then the hint for ETAL is that there's more people. We actually had 4 siblings that inherited this property. There was 4 names that should have been on the listing agreement and on the contract. This is just a little hint there for you guys, okay? You will get a copy of the slides after the presentation. Kevin will give me the list of everyone who's here, and I'll make sure you guys get this and some other resources I have for you, okay? So if a seller is an individual, obviously the individual is signing off. All the individuals must sign off to have a fully executed listing agreement, contract, and then after, all 4 of them or all the owners will have to sign the deed, okay? But what if the party's a trust? Has anyone ever worked with a trust as was a seller? Okay, a trust is a estate planning tool that we use in the legal space to avoid probate and to avoid guardianship and to pass assets down, build a legacy, etc. So that is what a trust is, and a trust can own assets, okay, including real estate. It's actually a really smart thing to do, is to own your assets in a trust, especially real estate, because we avoid probate. We'll talk more about that later. So who is authorized to sign the listing agreement? Who's authorized to sign the contract? And who's authorized to sign that deed? That's a trustee, okay? The trustee is who's authorized. How do we know who the trustee is? Well, on the deed that was that's going to be registered on the property appraiser, they'll have the most recent trustee there. However, sometimes we know that that trustee is on the deed. They'll say Melinda Grimaldi as trustee of the Grimaldi Revocable Living Trust. Okay, so Melinda Grimaldi, yes, that's a trustee because it says trustee there, right? But what happens if something happens to me? Sometimes it's not current, right? So if the person matches who's on there, you're good. But sometimes the person dies, right? Or sometimes there's other issues of why they're not the trustee anymore. So to be able to tell who the backup trustee is to look at generally the trust document itself or the certificate of trust. Okay. Sometimes trusts have restrictions to sell, but that's another class. That's not really for you to determine. But what you need to know is if you have a trust that owns a property, you need to make sure that the trustee is the one that's signing off, not the beneficiaries, not the heirs, not the future owners of that are going to own that trust. Not so it's a trustee, okay? And you could look at the prior deed to find that out. All right. Let's talk about an LLC. All right, an LLC, the limited liability company. Okay. If it's a Florida limited liability company, where do we go to look at to see who has authority? Sunbiz. Great. Thanks, Carlos. Sunbiz, if it's a Florida LLC, is where we're going to go look to see who has authority to sign your listing agreement and your contract. So a manager might be the one with authority, a managing member if it's an older LLC, an authorized member, or just a member, right? So you should be able to tell from Sunbiz who has authority to represent the company. How can we tell if they have authority further? Like, are they allowed? Are there restrictions? So title is going to require, or the attorney is going to require, a copy of the operating agreement. So as you're doing your intake, if there is an LLC, as you're opening your file with the seller and they decided to hire you, you want to ask them, do you have an operating agreement for your LLC? There are many LLCs that do not have one, but if this is one that does, we need a copy of it. We need to find it because title is going to require it for the closing. And the operating agreement can say this property may not be sold, or to sell this property, you need approval from this person. And so that's why we need to make sure we have authority. But generally speaking, that is a higher level of due diligence, right? That title will do. But you could already get that paperwork collected in advance, and you'll be able to move forward on that listing agreement and contract. Okay. What about if we have a seller that's a party, right? What if the seller is, a seller that's a corporation, excuse me. The president and the vice president by default have authority to sign the listing agreement and the contract. So you go on SunBiz, right? Same place as the LLC, we go on SunBiz, we pull up that information and we know what we can do and who can sign. They could also give somebody else authority to act on their behalf. That's going to be with a resolution or with an additional paperwork. But usually SunBiz will be enough to get you started, to know who needs to sign your listing agreement and your contract. What if the party's an estate? Parties in a estate mean that the person that owns the property has died, right? So can the property be sold? Well, sometimes the property appraiser will know that they're dead and they'll say estate of and someone's name. And that's a hint to you that this is an estate, this is a probate case. So who has the authority to sign your listing agreement and your contract when the property is an estate? That's a personal representative. So who's the personal representative? The personal representative, if you have a will, the will say, my personal representative shall be so-and-so and backup so-and-so, right? But sometimes there is no will. It doesn't really matter. A person is not a personal representative until a court appoints them. So the probate case must be opened and there must be a court order. It's called an order appointing a personal representative. And that is signed by the judge. Generally speaking, you can get that within a few weeks of filing the case. So if the first question is, has the probate case started? When someone wants to have sell their property and you know that their family member is deceased, say, well, has a probate case been started? Yes or no. If they say no, you already know they have no authority to sell. So what you want to do is get them in touch with a probate attorney to move the case forward so that you do have the authority to sell. I know there's always a lot of questions about probate and estate planning. So I do have a class on probate. It's for CE courses. It's a whole other class that builds this out even further. But to keep it simple, the case has to start and we need a judge to sign the order appointing them. Once you have that order, you can list the property and you can go under contract. But know that once we go under contract, we need to get court authority to sell. So it's a little bit more paperwork needed. You want to make sure that they have a probate attorney on the file working on that and is familiar with real estate transactions. Okay. Any questions so far? I don't see any questions. So I'm just going to take a pause here. So death of a property owner does not necessarily mean we have probate, because some deeds have built-in inheritance. Does anyone know of some examples? Maybe you want to put in the chat of some examples of some deeds that have built-in inheritance? It's just so quiet. Normally in the live class, everyone's like, oh, so maybe because it's Zoom. Ladybird deed is a good example. Thank you, Carol. For a right of or owning property with a right of survivorship. Yes, as joint tenants with right of survivorship. Yes, there's built-in inheritance there. There's built-in inheritance with when someone owns a property as husband and wife. There's default built-in inheritance there. And so when the first person passes, we have built-in inheritance, right? So we can avoid probate. And all you need really to verify there is a death certificate, right? Did that person really die? Because otherwise, then that other person's signature is not needed. But I will say this, if they are dead, do not put their name on the contract. Do not put their name on the listing agreement. A dead person can't enter into a contract. It's only a living person, right? I've seen that too. So what you're going to do is just drop, if there's built-in inheritance, you just drop the name of the person who dies and just put the living people that are left. And they're the ones that are that have the authority for the listing agreements and the contract. Okay. Sometimes it's tricky and you're not sure if there's built-in inheritance. That's where it's good to phone a friend and have an attorney look at your deed, look at your prior deed, and be able to tell you, oh, this is this type of deed and this is where we're at. So I'm happy to be that person for you. I'll share my information at the end. If you're not sure if probate is required or not, I'm happy to be that resource. Just shoot me an email. Because probate is a cumbersome thing, right? Probate can take anywhere from 6 to 12 months. Probate, it takes costs anywhere from $10,000 to 3% of the estate's value. We want to avoid it if we can, but it is what it is when we're dealing with it, right? So, but remember, we talked about this now, on a few slides. With probate, we want to make sure that we have authority to sell, that we have the PR appointed. So those are the two big things for the purposes of a real estate closing. All right, but let's talk about homestead. Who here knows what homestead is? What type of properties qualify to be a homestead? So it can be a separate structure, like a single family home, a condominium, or a manufactured home. The manufactured home, that's a mobile home located on owned or leased land, as long as the individual living in the home owns it, right? And it's a primary residence. It's their residential home. Okay. Now, there are 3 ways that homestead impacts a property. And you should be aware of all 3 of them. The most common that you all know about is the tax exemption. In Florida, homeowners must live in their home to qualify for the tax break reduction, as well as a cap on the increase, right? So the property appraiser cannot increase taxes more than 3% year after year if it's a homestead property. Otherwise, every other property that's not homestead, it's fair game to increase whatever they feel the value is. So it's a reduction and a cap on increase. Okay. So that's part 1. Part 2, we have creditor protection. This is why a lot of people who think they're going to get sued dump all their assets in their home. So creditor protection basically says that your creditors cannot access the equity or the foreclose on your home when you owe the money. There are exceptions. And there's no cap on this, right? Generally, but there are exceptions. Who are the 3 super creditors? Who do you think can still foreclose on your home?
The IRS.
IRS, definitely. Of course, the government is going to give themselves a carve out, right? Think about
taxes.
Taxes, yes, taxes is there. Lender is there. So any type of taxes, of course, a mortgage on the property, right? The loan on the property. And last but not least, contractors and material men that worked on the, yes, HOA 2, and contractors or material men that worked on the home, on that particular property, not on other properties, this particular property. Why? It would be unfair to hire a contractor to do all this work or provide you materials and then not pay them, right? Even if it's your homestead. So they carved out that exception as well. But there's a lot of notice requirements for that. And so by knowing this is why we do name searches. This is why we do we do title searches, right? To see if there are mortgages on the property, to see if there are contractors filing notices of commencements or liens on the property, and to see if we have to pay any past due taxes, IRS liens, etc. Okay, but why I want to talk to you about homestead is what I call the family protection. The family protection is my term. That's just what I call it. But what this law says, this part of homestead law says you cannot transfer, sell, or encumber a homestead without spousal consent. You also cannot give your home, your homestead, to anyone other than your spouse or minor child, if you have a spouse or minor child. But that's not the purpose of why I'm talking to you about it. Is you cannot sell a homestead without spousal consent. So this is where I want you to think about this. It doesn't matter when the property was purchased. It doesn't matter if the spouse is on title or not. It doesn't matter. It doesn't matter if it is your homestead right now and you are married right now and you need to sell right now, your spouse must consent. There's no exception. Okay? And let me tell you something. In Florida, there's no such thing as separation. So you're either married or you're not. Any questions on this? There's always so many questions on this. There's always like, yeah, but what if they bought the house before? What if they have a prenuptial agreement? What if no? There's no what ifs. Okay, here we go. We got one. What if you own the property in a trust and claim homestead? Same thing. If it's your primary residence, you must have spousal consent. Okay. So there's no exception to this. So when you're sitting at your listing appointment and you're asking questions about the property, etc., you need to ask if it's not already abundantly clear to you that it's their primary residence. You need to ask, is this your primary residence? Are you declaring homestead on this property? If you don't, and ask those questions. And then if they say yes, and they're not there with their spouse, the next question is, Florida law requires spousal consent for the sale of homestead property. Your spouse is not with you here today, so I have to ask, are you married? I have to ask, are you married? You have to ask. Why? There's deals that fall apart at the closing table because spouses don't want to sign, or the spouse they've been separated for 20 years but they're still married, or the spouse is traveling and they're pissed off and don't want to sign off. There's so many. What if there's more than two spouses? Well, there could only be one. The second one is not a real spouse, right? It's the first one that's there. So it's the first one that's going to have to sign off. That's a whole other can of worms, right? If there's more than two spouses. All right. Does everyone understand? We must have spousal consent. And so we don't want to wait to find out the final hour that there's a problem. Oh, I'm separated. And so I want you to be clear with them. Oh, there's no such thing as legal separation in Florida. It's either they're married or they're not. Right? And so you need to know, and you say, I don't mean to pry, but we want to make sure we have a smooth clothing. What if there's a prenup? It doesn't matter. This doesn't mean that they're going to get the asset. It doesn't mean that they're going to get the money from the sale. It just means they need to consent to the sale. Does that make sense? They need to sign up on the deed. All right. So how does all these questions in these slides impact the seller? Proper intake. You want to ask the right questions. Question from Vanessa. What is the best way to pass a property down to your child, stepchild? Mom and stepfather have them in the will. So that is a very good question. And I teach a whole other class just on this. Generally speaking, you want to avoid probate with real estate. Minor, if their children are minor, you definitely don't want to give it to them outright because minor children cannot inherit. So this is estate planning and understanding the rules of estate planning. So what I'll do is I'll send you another class that you can take if you're interested in estate planning. I'm getting a message, Kevin, that there's a few people in the waiting room, but I don't see anyone in the waiting room on my end. So I'm not sure. Thanks.
We're good here.
Okay, good. Okay, so here, Santiago. See, I know these questions, they start to come up a little bit at a time. If they are separated but still married, does the spouse need to be in the listing appointment? So that's a great question. Do they need to be in the listing appointment? Technically, no. Should they? Should you make sure they have the buy-in to sell? That is the question, right? So they don't need to sign the listing agreement, but it's always like, should they? Should you get the buy-in of the spouse? Because otherwise you're working your tail off for that to sell that listing. And nowadays it's a little harder to sell, right? It's not like you just list it and it's sold, right? You're listing it, you're taking pictures, doing open houses, it's a little different, right? So you want to make sure. We want to make sure that we have their buy-in. So I would say generally, yes. Generally, yes. I see several of you are sending me private messages about the estate planning class. I will share it with you all with the slides. Point taken. And I'll also give you a chart that has all the different sellers and who needs to sign what documents, etc. Okay, give you guys some guidance there. All right. So here's a good basis for you to start thinking about your intake. You should have a copy of their ID. Does it match the property appraiser? Are there spelling issues? Do we have additional owners not there at the appointment? Are there missing owners on the documents? What type of ownership do they have? Do we have built-in inheritance? Does somebody die? Right? Who needs to sign if it's an entity? Asking, what is the motivation for selling? Oh, then you're like, oh, I'm getting divorced. Ah, red flag, right? Okay, where's the spouse in all this? If you ask why are you selling? Sometimes you'll get information that way that can trigger other things. Are they foreign? What is their marital status? Was any work done on the home in the last 90 days? Do you plan on being present for closing? Do you have any big travel plans coming up? All these are important parts to set the expectations, to get your file set up, and to give the information to title to make sure you know they know what's going on. Okay. All right. So I'm presuming most of you work in Miami-Dade and Broward, right? Because we're here with the Miami YPN. So I'm gonna let me know if anyone works in a different county. I'm happy to give some other feedback on the other counties. But generally speaking, buyers choosing title agency in Miami-Dade and Broward. So a lot of times I see agents, listing agents, crossing off the escrow block here in the escrow agent information, and they're putting their title company's information, right? And so they think a lot of times that they're changing who's doing title, but who's doing escrow, holding escrow, and who's doing title are two different roles. A lot of times it's the same company, but it's not necessarily the same, doesn't have to be. So if you want the buyer to choose a different title company than who they have as the escrow agent, this is not how you change it. Okay. All right. When we start to get offers, and we're looking at different offers and we're comparing, I want to, not all softwares, now you're going to hear me say this, not all buyers agents are created equal. Not all these offers, the math is not always going to add up. I've had deals where the math isn't mapping. All right. Alexandra, I'll answer that question for you later in the presentation about how do we confirm who the title agent is. All right, so let's talk about the effective date. So when's the effective date? So Sonia is in Marion County, seller pays for title there. If you're in a seller chooses like Palm Beach or most of the other parts of Florida, seller chooses, you should be listing who seller chooses in the MLS. This way, buyer's agent knows who should be holding escrow because most of the time it's the same person. Okay, so let's go back. Let's move on to effective date. Effective date is when all parties agree and sign. Yes, partially, but we need it to be also delivered. The key is delivery. So all initials have to be placed on all the counter offers and all the changes. We need signatures on all the pages. We need, if you check off a writer, it must be filled out and provided. And then from there, it needs the last person doing the last initial, the last side. If it's the buyer's agent, it needs to be delivered. So if it's delivered at 11:30 p.m., tonight, it's going to be the effective date's going to be today. If it's going to be delivered because the agent fell asleep and the client signed after they fell asleep and they're sending it in the morning, the effective date's going to be tomorrow morning. Everyone good with that so far? It's not just all initials agree and sign, it's by delivery. Okay. Now, let's say today's the effective date. We have 3 days to calculate. And this includes the riders, right? All the riders included and checked up have to be provided. All right. So calculating deadlines. If today's the effective date, today's Wednesday, we have 3 days to make escrow. That's the default for the first escrow. Let me hear in the chat. When is escrow due? If today is the effective date. I see Vanessa said Monday. Monday. All right. Does anyone think it's Friday? Does anyone think it's Saturday? Okay. I'm presuming the quiet means everyone votes for Monday. It's Monday. So nice work. So you never count today as if today is the effective date, today is not day one. Day one is a day after the effective date. Day 2, right? So that's Thursday. Thursday's day 1. Day 2 is Friday. And day 3 is Saturday. However, it cannot land on a weekend or a holiday. So it's going to roll to Monday. Okay. So a little important part here or thing to remember is that it's still midnight. So you can deliver if it's a deadline or that requires a cancellation, you can give that all the way up until midnight. Okay. Now we are counting days by calendar days. It's just that we can't land on weekends and holidays. So you count weekends and holidays in your count. It just can't land there. Okay. Any questions on deadlines? It's super, super important as a listing agent that we are fully executed. You want to make sure you're not missing initials. You want to make sure your buyer is tied to the contract. You want to make sure that that escrow is actually at stake. Because if you don't have a fully executed contract, now the buyer has wiggle room. And as a buyer's agent, as a seller's agent, a listing agent, as a seller's attorney, I want to make sure that buyer is in the contract. Other than the contingencies, they're in it, right? That the escrow is in it. Okay. So it's our job to double check, right? And so we help our clients double check. We're like going through, making sure missing initials, missing writers. We do that transaction coordination that way to make sure that escrow is tight in the deal. Question, what about holidays? You count holidays, you just can't land on a holiday. It will roll to the next business day. Okay. Now, don't let this overwhelm you, this slide. It's there to show you something. We've had this is 2 years ago, I think it was, we had some changes to the as-is contract. And I want to show it to you because people are still learning these changes. And I want to make sure that you are aware of it. Here, this is if you are the listing agent and your property will have a tenant staying after closing date. So the buyer is buying subject to a tenant. It is your responsibility to make sure this box is checked off. It is your responsibility to make sure that the buyer's agent on the MLS is aware that there's a tenant on the property that is not leaving before closing. If this box is not checked off, the seller is required to give the property free and give buyer possession. So we don't want to put the seller in a breach of contract that they can't give possession, right? So it's important we check this off. Okay. All right. Assignability. As a listing agent, as a seller's attorney, we never want to release the original buyer from liability. So the default If no box is checked, then buyer may not assign is fine. Or may assign but not be released is the max we should go when we have a seller. So option 2 or option 3 or box 2 or box 3 on this section here. We want to make sure we tie that first buyer to the liability in the contract. Okay. Now, I'm going to go through, hang on, let me stop sharing for a second. Because I need to give these warning. You're going to see slides about the financing section. I want to tell you all, we're looking at this from the seller's point of view. I teach this class from the buyer's point of view as well. And so we can go on and on for an hour just on the loan portion of the contract and all the questions, especially from the buyer's angle. I'm going to be explaining this to you from the seller's angle. So that if you want, well, maybe we could do a class from the buyer side, Kevin, another time and do the angle from that way. Because I know this is going to happen. It happens every time I teach this class. So please, if you have questions, let's limit them to the seller side right now so we stay focused on the purpose of this presentation. All right, let's do it again. So I don't want you to, I'm showing you screen clips of the contract so you can do that. Okay, that's step 1. You guys should see, do you guys see my screen? Okay, so all right, so the buyer has by default 5 days to apply, right? And as a listing agent, as a seller representative, you have the right upon written request to get updated if the buyer applied, how the loan is processing, if there was an appraisal done, if the appraisal has met the value, if the loan approval has been obtained, and if there's any property related conditions of the loan approval. The contract gives us the authority as the seller's attorney, as a listing agent, to get that information. Okay. Loan approval also is defined to include an appraisal that meets the value we need. So if you are being told your buyer has loan approval on the other side, but you know they didn't do an appraisal, they by definition do not have loan approval. Okay, we good so far? Okay. All right. Now, if buyer gets loan approval, buyer is required to notify us, the seller's team, that the approval has been obtained. If they don't tell us in writing, the buyer waives their right. No one realizes this. No one is doing this always the right way. We must communicate the loan approval to the seller side, otherwise it's waived. So what happens if it's waived? There are no more contingencies. It's as if it's a cash deal. Okay, if the buyer lets that deadline pass. All right, so that's just be aware that's what that means. So it's waived even if the loan approval is obtained. If they don't notify you, it's waived. Okay. Now here's the kicker that most listing agents don't know. If we don't get notice on the seller side, the seller has the right to cancel the contract within 3 days. So how many of us, I'm sure there's many of you there, especially if you're on the listing side, that you lose faith in that buyer and that lender. You're just like, man, this was a bad one to go under contract with. And sometimes we even had that backup offer or that cash deal that came afterwards, right? You actually can cancel within 3 days of expiration if we don't, if the buyer fails to provide loan approval. We have a 3-day right to cancel. I've never seen this used ever, and since it's been put in place, but let's see, maybe one day it will be. All right, next. What happens? So we get this loan approval. It's sent to us. Closing is in 5 days or 10 days or whatever. and then that buyer can't close. That escrow still goes to the seller as long as the seller's not in default, and the title's clear and all that stuff, right? And as long as it's on a property related condition. So if buyer loses their job, if buyer got a new credit card, financed their, a new car and then mess up their loan, or, the lender didn't rate lock or whatever in time, or when the rates went up and now they're priced out, whatever the reason, it doesn't matter. The seller will get escrow. Now, what's a property related condition? So the question here from Juan is that after 30 days, seller can cancel if no notice. It's 3 days after the loan approval period expires. This is if it expires, one. Okay. So seller still gets escrow unless it's a property related condition. What's a property related condition? Does anyone want to share in the chat what they think is a property related condition of the loan? I see some answers coming through. Okay, so let's go through these one by one. Thank you for these answers. So if the buyer has a contingency to sell his property first, that depends. Buyer can get their escrow back as long as they had the rider checked off that their purchase was contingent on the sale of their house. Otherwise, it's not an excuse to get your money back. All right, so that's Madeline's answer there. Alexander put appraisal. No, appraisal is not appropriate here to get your money back because it was part of, they should have already had it as part of loan approval. Actually, it specifically excludes appraisal. You'll see here on line 155. Then we have from Bruno, loan approval and the closed conditions from the loan. Nope, closing conditions do not matter. It's only the property related conditions of the loan. Carlos added insurable. Is the property insurable? The funny part of all this is that what a property related condition is not defined in the contract anywhere. So we don't know what it means. So maybe insurability. If it was my buyer, I would make sure that they had their insurance during loan approval period, because insurance is so volatile and it's not defined. But this is not a buyer class. If the property is destroyed by a hurricane in the meantime, note that's dealt with in the force majeure clause. So that's something else. Property condition change, hurricane. Nope, that's something else. That's in the force. You can use force majeure, but we're talking about the loan approval. What if there's a title defect, but the seller is actively working on it to resolve? Well, then seller needs more time, so then buyer has more time to get their loan approved, right? So property related conditions is not defined. So it could or could not mean insurance. It definitely means any property related condition based on the loan type, right? So we know VA loans have permit. You need to make sure that on a VA loan, you don't have termites or wood destroying organisms or evidence thereof, right? So if the seller does not do their wood destroying organism tests or repairs or whatever it is to remove live infestation, that is a way out. The same thing with an FHA. FHA loans have certain property related conditions that, like, the property must qualify in certain things. Well, if we don't have those property conditions, that's a way out, right? Of what needs to be fixed or changed. I would say that it's literally physical property. But what about things like the condo budget or condo assessments, special assessments, or condo condo litigation, or condo flood insurance, or there's so many things in a condo, right, that can screw up a loan. Well, We don't know the answer. I went to a Florida bar real estate reptile convention meeting, and where they were talking about these changes. I said, what about this? What about that? And they said, we don't know. It's not defined. So we could argue it to our favor, but what I will say is, it's buyer's burden to prove that it is that, right? So, but know that it's not defined. I see a few questions here. Let me see if I caught them all. All right. Melinda put a question, another Melinda in Zoom here. If a buyer's side doesn't notify if the loan is approval, about the loan approval, even if they have it, it becomes a cash deal. Yes. All right, moving along. Let's talk about closing costs. All right, seller closing costs. Really important to be aware of the difference between the standard contract and the as-is contract. You'll see here the top, these are screen clips of the closing cost section. The top part here is the standard contract. You see seller is required to make repairs in the standard contract. Huge deal. The contracts look very similar other than a few words on the first page. So you want to make sure you know where your offers are, what form they are being used. And I would say if you want to require a certain template to be used, put that even in your MLS. If I have a seller, I don't like standard contracts. I don't want to force my seller to make any repairs. So the as-is contract is what I use for my sellers. And if it comes through on the standard contract, I say to the buyer's agent, send it to me on an as-is. All right, so just be aware because they look really similar. All right, so now this is, who knows what's going to happen here on 6%, right? We've had some recent changes on commission stuff with all these lawsuits. I don't know what's going to happen, but for now we're still at 6% in transaction fees. Make sure your transaction fees are disclosed on the listing agreement. Documentary stamps are the standard customary seller cost. That's based on the sale price. We have estoppel fees for every association. Sometimes there's multiple associations for one property, master, tower, things like that. There's one for each. The average cost is about $350 for that. If they're in arrears, it's going to cost more because there's an attorney that's on it, that's doing the collections. Now, here's a big one. The attorney or settlement fee. So as a seller in Miami-Dade and Broward, a seller has two options for assistance with a closing. Because the standard is in Miami-Dade and Broward that the buyer chooses and pays, right? So they choose a title company. So the seller can hire the buyer's title company to do their seller's docs, or they can hire a lawyer, a law firm, to represent them and do documents. Do not refer your sellers to a title company that is not doing the closing. That is the unauthorized practice of law. Title companies are not permitted to draft docs in a closing that they're not issuing title insurance for. We see realtors referring docs prep to title companies all the time, and it's not proper. So don't do that. You're referring the unauthorized practice of law. Also, it doesn't matter that title company is owned, operated, or has an attorney on staff. It must be a law firm, not a title company. Okay, so there's two options. The seller hires a lawyer in a law firm, or the buyer's title company. Okay, Miami-Dade and Broward. If we're using the standard contract, the seller is going to be required to make repairs, depending on how it's filled in here. Otherwise, it's just a maintenance requirement. Then if there's any title issues, we need to clear title issues, and the cost of that will vary depending on what needs to be done. Then we have FIRPTA, which is a foreign seller. For foreign sellers, we need the preparation of the documents. It could be, I've seen it anywhere from like $750 to $1,250 or so for FIRPTA documents to be prepared. That is a seller cost, plus the withholding, 15% of the gross proceeds are taken off the top. We'll talk more about that later. The mortgage, right? Obviously. Then we can have maybe junk fees. If you have a title company trying to stack junk fees on their closing statements, those are like BS fees that really are not, the seller's not required to pay. If you hire an attorney, they should be able to wipe those fees off the closing statement. 1031 exchange fees, mobile notary fees, property taxes from previous years, taxes from the current year. As of today, today's November 1st, tax bills are out. They should be coming in today's mail, right? I just realized that. So yeah, so tax bills as of today. Example of, so someone asks, what's example junk fees? Like storage fees, scanning fees. Those are junk fees. Those are junk fees and, you know, BS fees. Okay. All right, so what else? Let's talk about the title section. So here's the Miami-Dade Broward provision that we always talk about. This is what we see most common, but we have the seller chooses and pays and buyer chooses and pays. So what's the difference? In the seller chooses and pays, seller's paying for the searches, the lien search, title exam, and for the owner policy. Buyer pays for the lender policy. And buyer chooses and pays, buyer pays for all four. And the Miami-Dade split, the seller pays for the searches and the buyer pays for the policy. So this is what's standard here, Miami-Dade and Broward. The difference between the buyer choosing here and the buyer chooses and the Miami-Dade Broward is about $500 to $600 of search fees that the seller is going to have to pay in the Miami-Dade Broward split. If the seller has to pay title insurance, it's going to be based on the purchase price. It's a state regulated amount. And then we have proration. So what are things that are prorated? We have ad valorem taxes, non-ad valorem taxes, maintenance fees, special assessments, rent. And then we have to credit the buyer for last month's rent, security deposit, and any future rent payments if there's a tenant staying after closing. So now really, really, really important here if you have a seller and it's a condo. I'm going to put your attention to section CI. This is where we need to disclose for the seller if there are any pending special assessments or items that have been on the agenda or reported in the minutes in the last 12 months. Tell me what condo building has not talked about doing a special assessment in the last 12 months on the agenda or in the minutes. We must disclose it, even if we don't have too much information. Then if we want buyer to take it over, right, we need the buyer, we need to check off buyer, but some associations do not allow the buyer to take it over. And so when we get the estoppel, they require it to be paid in full. And then it turns into a conflict. So as a listing agent, you must be aware, you must ask the questions is, can the buyer take over the special assessment? And we must be providing all the different, all the different documents, because if we get a receipt that the condo docs were received, because if they were not received, a buyer can close the day of can cancel the contract the day of closing. They have 3 days to cancel from the date of receipt of all the condo docs. And the condo docs is not just the condo docs, it's also the articles of incorporation, the bylaws, the rules of the association, year-end financials, frequently asked questions, et cetera, et cetera, et cetera. So as a listing agent, you want to make sure once you get your listing agreement signed that you start to collect these documents, because what we want to do is close our contingencies as soon as possible. So we should be giving these to the buyer and the buyer's agent right upon execution. You could even have them on your MLS as an attachment. All right. If you are in Miami-Dade County and you live and you work in one of these cities, know that there's a certificate of reoccupancy. It requires the city to go in and inspect the property before closing. And usually if there's items done without a permit, this is where it becomes an issue, right? They're going to go in and say, oh, this was done without a permit, or here's a code violation. As you can imagine, the city of Hialeah, how that it's always a problem to do a closing there with these certificates of occupancy. It's always a big problem there. But remember, With closing costs, everything is negotiable. Yes, we have standards, right? And defaults, but we also have everything is negotiable. Okay. All right, I see some questions in the chat, so let me go there before I talk about this next slide. Once disclosed, is the owner has limited information, does it turn into a buyer's due diligence issue? If you're talking about condo related documents, no, it is the seller's responsibility to provide all the documents and all the information that they have. If they don't have it, the seller must go to the association and get the information that they're required to give. All right, if the property disclosure enough for the seller to confirm the special test? No, the property disclosure form is not enough for special assessments. You must disclose it on the condo writer. Let's go back. I actually had a deal where a realtor had to put his commission in because he disclosed the special assessments in the wrong place. It must be here. If it's not, it's very clear that it must be here. CI. Disclose active special assessments, or if there's a special assessment on the agenda or reported in the minutes on discussion. This will cost you guys money. I guarantee it if you don't do this properly. Because the sellers will be pissed. Because what do the sellers not know? The sellers don't know these documents. They're just going to sign here, here, here. If you don't have a conversation with them, confirm it in writing, document your file, that there are no special assessments on the minutes, this or that, then what's going to happen? They're going to say, you didn't tell me. And then what's going to happen? Then you're going to have to throw some money from your commission to get the deal done because you made the mistake and didn't tell them. So what I'm telling you guys to do is when you open your listing file, right? You're under contract. It's just a listing. It's a condo. You need to collect the information up front. Tell your sellers, it's going to cost you money if you don't disclose properly. Please go and get these documents and collect this information. This way, you're ready with your condo writer and the information in the condo writer when the time comes. So what I suggest, if I was a listing agent, what I would do is collect all the information up front as soon as possible before we're even under contract, and collect this information, fill it out, and attach your filled out condo writer and all condo docs and add it to the MLS. So this way, the buyer's agent already has the information. Okay. More questions here. Are you required to give a seller's disclosure or only if asked for? Sellers are required to disclose. Whether you do it on the form or other ways, they must disclose. So that's the rule. Contractually, in a residential contract, they must disclose. Give a property disclosure. Okay. They can do it on the form or otherwise, but might as well just do it on the form. And attach it to your MLS. And just get the disclosure out there. You should be filling that out with your seller once this listing is signed. If special assessments are against the property, why to force a seller to pay it at closing? Is that legal? So it's not about legal, it's contractual, right? Depending on what the association rules are, some associations do not allow the special assessments to be assigned to a buyer to take over. If that's the case, then they have to pay it. So you got to pay to sell. Some require a fee to transfer to the buyer. Some just allow the transfer. You have to inform yourself before you go under contract, because if the seller is required to pay for it in full, you need to use that in your negotiations of the sale price. Because if the buyer is taking it over with all the special assessments paid, that's value to the buyer. The buyer doesn't have to deal with it after, doesn't have to pay for it, right? The worst thing you want to have is you negotiated thinking your buyer is taking it over, so you reduce the price a little bit because the buyer is taking over special assessments, and the buyer is not allowed to take over special assessments. And then your seller gets a double whammy, right? So you want to make sure you include that in your process. At what time do you get the certificate of reoccupancy? Certificate of reoccupancy, I would say once you know your buyer's moving forward during the special, during the inspection period, you could start to collect your information. Okay, so The certificate of reoccupancy is buyer specific. They will list the buyer's name on there. So, figure out the process, get yourself informed. But if you don't do it too early, also know their timeframes. But if you do it too early and the deal falls through, then you're gonna have that issue, right? But also, if the certificate of reoccupancy becomes conditional, then you have an issue there too, right? They're like, oh, we'll give it to you, but your seller has to fix these things, or the buyer's got to agree to take it. And we don't want to be dealing with that the day of closing, right? We want to have time to negotiate that. We want to have time to maybe fix something and have a follow-up, a reoccupancy inspection done. Alexander asked, so we should ask for the minutes? Yes, definitely. Definitely. Okay. So in the as-is contract, seller is not required to fix permits, but they are required to disclose it. So if you have open, expired permit issues, you must disclose it. Certificate of reoccupancy is the seller's expense and the seller's responsibility, but they don't usually know about it. So generally speaking, the listing agent is the one coordinating it. All good questions. You see here in the permit section, in the standard contract, we have a section here up to a certain dollar figure or 1.5% of the purchase price for costs associated with closing out open or expired permits. That's not the case on the as is, but on the as is, what ends up happening is a lot of people put that permit clause in the additional section to say that the seller shall close them out before closing. Now, I'm not going to go into the standard contract inspection period fiasco. What I will tell you is this. If you're a listing agent, almost never do we want a seller required to make repairs. We want our seller to agree to repairs. They're going to be very unhappy if they don't realize they're signing and guaranteeing a certain amount of repair fees, right? And the standard contract requires buyer to get an inspection. If the seller doesn't agree with the inspection, seller has to get their own inspector. If they conflict with the reports, and they got to get a third inspector, and then there's deadlines. Like you're spending 30 days dealing with inspection BS versus moving on with the deal. So I would suggest my personal preference, it's not a right or wrong, is to just use the as is and require the as is for the seller. And that you could always negotiate repairs if necessary. Okay, this is all the inspection period. Now, additional terms, guys, don't get creative, right? I always say this, don't get creative. If you need to get creative, you need to have an attorney on board drafting those terms. Sometimes the deal requires creativity. Sometimes deals require additional clauses to be drafted. You shouldn't be the one doing it. I've seen agents get in trouble by getting too creative. As a seller's attorney, when I work seller's attorney's files, I'm happy to draft a clause and there's no extra cost for it. So don't, and I'm sure, I don't know how other people do it, but that's just our policy. And why I say that is, if you're going to be referring to an attorney anyways, have them look at the contract and say, hey, we need this clause added, or will you review this clause that I prepared? Is it okay? Use the people on your team accordingly. And if you don't have someone that's not going to help you like that, or a title company can't help you like that, right? So you need an attorney to help you with the language. So take that into consideration when who you're working with. Remember, I said this before, not all agents are created equal. So not all agents will realize that their buyer has to apply for association. I've had deals where it's like the last day of closing and no one told the buyer that they needed to apply. So as a listing agent, you should know what the rules are. You should know where to get the information, and you should be able to communicate that to the buyer's agent. Talked about condo right already. Also, very important, if you're gonna promote your unit, if it's a condo, and you're gonna accept loan offers, okay, you need to understand loan guidelines and what is possible with your building. So that means you need to understand reserves, how much % down is required. Is there litigation going on? Is there master insurance? Are there special assessments? Because all these things can kill a deal. So as much information as you have in advance, you should be able to communicate this to a lender you know and say, hey, can this qualify for this type of loan or not? This way, when you are, because don't forget, as a listing agent, you're in charge of marketing the property. And if your property will never qualify for any type of loan, or if your property will never qualify for a specific type of loan, that should be super clear on the MLS. This way you're not entertaining offers from the beginning. And this way you're only entertaining offers that really will work from the beginning, right? We don't want to accept an offer, keep it tied up for 30 days, and then it actually was never meant to be from the first day. Underfunding of the master insurance is a big issue, yes. And how do we work with that? We have to deal with cash buyers. Almost always the association will not change their insurance for your deal, right? So that's the reality of that. Or seller financing, if the seller has the cash to do that, right? So they have to have the cash to be able to leave money on the table. When I bought my house, the HOA took 4 weeks to approve plus interview with the board members when they were available. How can I avoid that? As a listing agent, you should know what the turn times are and be very clear to the buyer's agent. You must do this by this time because they take this long to do it. So the listing agent, if you give the information up front, that's the beauty of that, right? So you keep the deal on track. Can you get this info in the condo questionnaire from the association? You can, but the condo questionnaire is not ordered until the lender is under contract. So a lot of these pieces you can acquire just by asking the right questions, or the seller can acquire from asking the right questions as an owner. So a seller, if a seller is foreign, and foreign means for tax purposes, they file non-resident returns. Not that they don't have a green card, not that they don't have a visa, right? Not that they don't have citizens. They're foreign for tax purposes. Then we need to withhold 15% for individuals, 21% for an entity. It's off the gross sale price. There's forms that need to be prepared by the CPA. These forms are prepared by the seller but signed by the buyer. There are exceptions. If it's used as a residence and under a certain threshold, we can do that. And I'll give you the slide that has all the information at this point. We're running out of time. If you have questions about FERPTA, I'm happy to address them with you offline. Okay, because it's gonna be a whole other class. If your property is in foreclosure or there was a previous loan modification, you must be aware that sometimes to get a payoff, we need an appraisal for the loan modification, and payoffs take much longer for foreclosure and loan modifications. So make sure that they hire their attorney early and that they don't waste time giving information into title. And other than that, if the seller's not going to be present at closing, make sure they have a power of attorney or sign early, because they will need to notarize. Or now we have Ron, so Ron's good. Remote online notarization. 1031 exchanges could also be a totally new class, but as a seller listing agent, you should be aware that if they're selling a property that's not their primary residence, you may want to let them know that they have the ability to not pay taxes on their gains right now, and they can defer and put all their gains in the next property. If they plan on buying, this is an opportunity for you to get maybe 2 deals out of 1, right? If it's not a primary residence. And other than that, I know we went over a little bit. That's a mouthful. So I'm open for questions. But in the meantime, while I wait for any questions in the chat, I'd love to just share a little bit more. My law firm is doing probate services. We did it for a while. We stopped because the market was too crazy with closings, and now we're back doing probate again. If you guys are interested in learning a bit more about how we operate, and if you need some help filling out your offers, if you're a new agent or need some coaching about how to work your deal, or want to learn about how we can help you grow your business, this is the Realtor Strategy Call QR code. I'll also send it in the email afterwards if you guys are interested in driving or something like that. I see some questions. I will be sharing the slides. Yes, I will. I think there's a recording also being done, so we could share that. The estate planning class will be shared. Yes, I do living trust, Victoria. So if you're interested, we could talk about that offline. And let's see what other questions come in. That's about it. Oh, look, one of my slides. You might, if you're a YPNer, you might know Darnell. He's one of the agents we love to work with. Here's a testimonial, so don't just take my word for it. Here's his. We are the best, fast closing, super responsive, beautiful office, always here to help me solve problems for myself and my clients. And this is a little bit about how we manage your deal. So we make sure, whether you hire the law firm or the title company, we'll make sure your contracts are fully executed. We'll confirm your effective date. We'll send reminder emails for all deadlines. We'll follow up with all the parties and the lenders and everyone involved. We'll report to you the status of your deal, and we help you save time and money with a lot of other tools and tricks. So happy to share more of that with you. Whether you have a TC or not, or an assistant or not, we can work with them, or we can help you leverage your time. So with that, we have office in Hollywood, satellite office in the Gables. We close the entire state. Thank you, Victoria. I thought the class, we crunched it a lot in, but we got it done. And it's been my pleasure. So with that, that's a wrap. Thanks, Kevin. Yay. Thank you.
Thank you very much. And I think we are off class for a little while. I don't think our next class is until the 29th, and it should be on Mastering the Gram with Cindy Summer Perez. So enjoy your November. We have rocked the market, I believe, 1 week from today at the Biltmore. There's a handful of tickets left. So if you're interested in attending that, that'd be great. And if anybody's going to be in Anaheim for NAR NXT, let us know. We'll have a booth there at the expo, and have a lot of great connections for you all across the United States if you happen to be there. So don't hesitate to reach out to myself at Miami YPN on Instagram. And we look forward to sending you more classes soon. And we'll have our business planning class, one of our biggest classes of the year, coming up in mid-December. More announcements coming up very shortly. Until then, go out there, be great, and
Awesome.
we'll see you at the end of the month.
I think I caught all your questions. If I didn't, just shoot me an email, guys. I'll be sending you an email soon, okay?
If I'm on my way home, yeah. Wouldn't it be crazy? Oh, don't you still amaze me? Wouldn't it be crazy? Oh, don't you still amaze me? Wouldn't it be crazy? Oh, don't you still amaze me? Wouldn't it be crazy? Oh, don't you still amaze me? If I'm on my way home, yeah. If I'm on my way home, yeah. Wouldn't it be crazy? Oh, don't you still amaze me? Wouldn't it be crazy? Oh, don't you still amaze me? Wouldn't it be crazy? Oh, don't you still amaze me?